So on the iPhone, please identify yourself just so we can rename you. You're on the iPhone, sir.
Devin O'Nellis.
Say your name again, sir.
Devin O'Nellis.
Oh, Devin O'Nellis. You're here for your 9 o'clock?
Yes.
I got it.
We have a Leslie Anderson, a Tavion McLeod, Dominic Maltor, and Miss Schmidt. Star Schmidt.
And she's sending me pictures. She said she's sending me pictures of someone get for
Yes.
firewall. We've got a couple of them. So we have Mr. Orlos here.
We need to rename the courtroom. I don't have the
Oh,
Are you talking about the dog licenses?
Yeah.
According to the Ingham County dog licensing information, is
All right,
currently
I'll
required by law for all.
rename. Courtroom
three.
3.
Yeah, that 4 months is correct.
Oh, there it is. Okay.
The other one. And Devin, okay.
Four months older. Yeah, that's the statute or the ordinance. Yeah, we will need. Yes, the church is
Right. So what case did you want to call?
You don't have Mr. Johnson, do you?
I do not.
All right. Who do you have, Mr. Harris?
I do a monitor and
And Lexi.
I do a monitor, I do a designer, and Mr. I guess I do her continues.
And Greg Reynolds. Oh, is it? I thought you were- okay. Then we can do that, right? So we got, you know. Okay, and you can do jobs too. We're just gonna check for performance. And the offerings that you have, and the rest of it will be dismissed. And that there's other information. Is it
Yeah, Dominic.
Dominic? Okay.
Yeah, but yeah, monitor and John.
Okay.
Good.
Go ahead, Mom.
Your Honor, we'll be ready on Dominic Molitor.
All right,
He should be
Mr.
on Zoom, Your Honor.
Molitor. All right, Dominic Molitor, we'll call your case next.
Okay.
All right, so we're on the record in docket 26011752. I'm sorry, Molitor. 26011817, 26011817. Appearances for the record, Mr. Decker.
Andrew Decker on behalf of the people practicing pursuant to MCR 8.120 under supervising APA Casti Kachukas.
All right, and you only have to make that motion once and it's granted today. Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Dominic Molitor, who appears via Zoom. Mr. Molitor, could you please state your first and last name for the record?
Dominic Molitor Sr.
All right, thank you. And you can hear me all right, Mr. Molitor?
Yes, sir.
All right, this is the time set for a pretrial in the matter. Mr. Decker, how are we proceeding? Would you like to defer to Mr. Harris?
My understanding, we're going to be setting this for a final pretrial, Your Honor.
That is correct, Your Honor. I've spoken with Mr. Molitor regarding the case and our options. At this point in time, we'd be requesting the final pretrial date.
All right, we'll set Mr. Molitor's case for final pretrial on
August 3rd at 8:30.
August 3rd at 8:30. All right, so we've set this for August 3rd at 8:30 for final pretrial. Anything else for the record in 2601-817, Mr. Decker,
Nothing further, Your Honor.
Mr. Harris?
Nothing from the defense, Your Honor.
All right, Mr. Molitor, we'll see you on August 3rd at 8:30. All right, sir?
Okay.
Thank you.
Leslie Anderson.
Leslie Anderson.
Hello? I don't know how to unmute my phone.
All right, Leslie Anderson, we're gonna call your case next. If you stay just like you are and unmute, you should be fine. So
Okay.
Leslie Anderson, you should unmute. All right.
Okay.
All right, so we're on the record in docket 2301-871. That is People of the State of Michigan versus Leslie Anderson. Appearances for the record, Mr. Decker.
Andrew Decker on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Leslie Anderson, who appears via Zoom. Mr. Anderson, if you could please state your first and last name for the record.
Leslie Anderson.
All right, Mr. Anderson, you can hear me all right?
Yeah, I can hear you.
All right, thank you. This is the time set for a pretrial on this matter. Mr. Decker, how are we proceeding? Would you like to defer to Mr. Harris?
I believe we'll be setting this for a final pretrial as well, Your Honor.
All right.
That is correct, Your Honor. I've spoken with my client regarding this case, and at this point in time, we would be requesting the case be set for a final pretrial.
Okay, we'll set for final pretrial on
August 3rd.
August 3rd
August 3rd.
at 8:30. Okay, it'll be set for final pretrial on August 3rd at 8:30. That'll be live in person on the 6th floor City Hall of Lansing. All right, Mr. Anderson?
Live in person? Well, the 3rd at 8:30.
August 3rd at 8:30. Anything else for the record in 2301-871, Mr. Decker?
Nothing further from the people, Your Honor.
Mr. Harris?
Nothing from the defense, Your Honor.
All right, Mr. Anderson, we'll see you live in person on August 3rd at 8:30. Thank you for your appearance today. You should be all set.
Okay, thank you.
Give me just a second.
Okay.
You don't know that's. That's how it's coming out.
I need a Jones.
All right, we're having a little technology issues, as you can imagine, with everything coming up at once. Mr. Harris, did you need to talk to some clients here?
Nope, I am ready regarding Ms. Johns, and I'm also ready regarding Aiden Gonzalez, who is outside.
From Aiden Gonzalez. All right. And Ms. Johns is joining us via Zoom. Is that correct? Anita Johns?
Yes, Your Honor.
It won't be the first. All right.
Sorry, sorry.
All right, so we're on the record. Ms. Johns, we'll call your case. We're on the record in 2601-629 and 2601-630. Mr. Decker, is it all right if I call these cases together?
Yes, Your Honor.
All right. Appearances for the record, Mr. Decker.
Andrew Decker on behalf of the people.
Mr. Harris.
Alex
Mr.
Rabat,
Rabat.
requesting permission to practice pursuant to MCR Chapter 8, Section 120, under the direct supervision of Assistant Public Defender James Harris on behalf of Miss Anita Johns, who is appearing via Zoom.
All right, that's granted, and you only have to make it one time today. And ma'am, you are Anita Johns, is that correct?
Yes, that's correct.
And you can hear me all right, Ms. Johns?
Yes, I can. Thank you.
All right, thank you. So this is the time set for pretrial in the matter. Mr. Decker, how are we proceeding? Or would you like to defer to Mr. Rabat?
We'll be requesting an adjournment for compliance purposes. The offer on the record has been made, and it would be proof of compliance as well as pleading to one of the open cases, and we would be dismissing the rest of the cases in review.
All right, is that your understanding, Mr. Rabat?
That is correct, Your Honor. We are looking to deal with some compliance matters.
All right, so we'll adjourn the pretrial. Does it matter what we call it? Yeah, yeah. Whatever we have room for. August 3rd at 9 o'clock for file 26-01629, and August 3rd at 3 o'clock. August 3rd at 9 o'clock, I should say. Almost wrote that backwards. August 3rd at 9 o'clock. So we'll set both pretrials for August 3rd, reset both pretrials for August 3rd at 9 o'clock on 26-01629 and 26-01630 for compliance purposes. Anything else for the record in either one of those dockets, Mr. Decker?
Yeah, Your Honor, I'd like to just make a correction that it is the defendant would plead to one count of the
Okay.
charges, not a full case.
So the offer was placed on the record. And is that your understanding, Mr. Raba?
Correct, Your Honor.
All right, with that understanding, anything else for the record, Mr. Raba?
Nothing further, Your Honor.
All right, so on 26-01629 and 26-01630, we've reset for, we've adjourned this pretrial for August 3rd at 9 o'clock for compliance purposes. That's all for the record on those two files. Ms. Johns, please keep in contact with your attorney, Mr. Rabat or Mr. Harris, so you can get them whatever information or whatever paperwork they need on these cases. Okay, ma'am?
Yes, Your Honor, I will.
All right, you're all set. Thank you for your appearance today.
All right. Thank you.
Then you said a name, another name, and I missed
I'm
those.
ready on Mr. Gonzalez. I believe he was sitting out in the hall.
All right. It's Aiden or Adon?
We're also ready on a couple of Mr. Smith matters, I believe.
Okay.
Joel Johnson,
Joel Johnson.
John Watson, once.
All right. Let's go on Mr. Adon, and then we'll go on. All right, so we're on the record in 26-01376. That's people of the state of Michigan versus Aiden Gonzalez or Don Gonzalez. Appearances for the record from the people.
Good morning, Your Honor. Grace Chavalier requesting permission to practice under MCR 8.120 under the supervision of Cassidy Kachukas.
All right, that's granted. You only have to make that motion one time today, and it's Ms. Shadley.
Ms. Chavalier.
Chavalier. All right, Mr. Rabat.
Alex Rabat appearing on behalf of Mr. Gonzalez. You please state your first last name for the record. Oh, you're adding John.
All right, thank you. This is the time set for a pretrial. This is a contempt hearing on an assault and battery contempt hearing. I have this. Ms. Chavalier, how are we proceeding, or would you like to defer to Mr. Rabat?
Your Honor, we're asking for an adjournment at this time to determine if the PA 53 violation leads to any additional new charges.
And is that your understanding, Mr. Rabat?
That's correct, Your Honor.
All right. So we will adjourn. So the bond violation was received on June 29, 2026, and then another bond violation on July 8, 2026. And this is a tether violation that we're adjourning. It looks like for drinking alcohol. And then it looks like this might end up in other charges. This was a drunk driving. Is that correct? Or portions of it look like there was probable cause for an arrest on an OUL third and a felony resisting and obstructing. So a decision has to be made by either Eaton County or your office. I think this is an Eaton County case.
Sorry, Cassidy Kachukas for the people. Yes,
All right.
the stuff with the offense date of that we have from 6:30 is out of Eaton County. We're still trying to find more information about
All right.
the Scram report.
All right.
Yes, I believe, and James Harris for the defense, Your Honor. I believe that's the case as well. The report I got regarding the violation was the violation on 6:30 involving the OWI third, the resisting, obstructing, and the open intox out of Eaton County. And then as far as I can tell, it seems like the report from July 8th was the Scram had the report for that violation, but we would need to look into that just to
Right.
confirm exactly and to confirm whether new charges were filed in Eaton County.
All right. So let's adjourn the bond violation contempt hearing. So 7/1926. Adjourn.
It's 2 weeks.
Is it about two? We can set it as early as 2 weeks, but I don't know if that takes care of what the information you have to receive from Eaton County.
If we could make it 3, just because
Yeah,
it makes it
just
so
in
we can do the
case,
reports,
yeah.
and then we need still 2 weeks to meet.
So do we have 3 weeks? All right, 3 weeks.
August 10th at 10.
Okay, so it'd be August 10th at 10 o'clock. At 10 o'clock. All right, Mr. Gonzalez, you're still under the same pretrial conditions for the A and B. So that'd be no use of alcohol or drugs, no assaultive behavior, no out-of-state travel, no contact with the victim in this matter, no possession of firearms. There's been a bond violation. We've adjourned the bond violation to see what Eaton County is doing with the bond violation. Anything else for the record? So it's been set for August 10th at 10 o'clock. Anything else for the record in 2601-376, Ms. Chevalier? And I don't know if I'm saying that right.
You're saying it right.
Chevalier,
Nothing
okay.
from the people, Your Honor.
Mr. Harris or Mr. Raba.
That's your honor.
All right. All right. You're all set, Mr. Gonzalez. Thank you for your appearance today.
Hang on, you had something.
You're asking about arguments. Yes, just generally.
Oh, you a pre-trial.
Do I know how? I think for the most part, I haven't. I've only shadowed James doing them. I haven't like.
Let's
actually
keep
gotten
that separate
involved
from this
with,
one.
just- I was trying to- was it- Let's just try this. I know.
Did we want to go on Joel Johnson? Mr. Smith?
That would be the answer question. Your Honor.
Right. Yeah, but who has that? Oh, okay. We can go on.
Yes. That one is mine. I think we can do that.
Who's that, Mr. Decker?
Devin Ornalis, I believe he is on Zoom right now, Your Honor.
All right. And then we have Mr. Johnson.
Yes.
Let's do Mr. Johnson first, and then we'll do Devin Ornelis. All right, so we're on the record in docket 2601-590. That is people of the state of Michigan versus Joel Johnson. Appearances for the record, Ms. Kachukas.
Thank you, Your Honor. Cassidy Kachukas for the people.
Mr. Smith.
Tyler A. Smith, from the Office of the Public Defender here in Ingham County. I do appear on behalf of Mr. Johnson, who's standing to my right.
And sir, you are Joel Odom Johnson, is that correct?
Joel Odom Johnson.
Joel, thank you. This is the time set for a final pretrial in the matter. Ms. Kachukas, how are we proceeding, or would you like to defer to Mr. Smith?
Your Honor, the people would ask that a second final pretrial be set and that Mr. Johnson be arraigned on the PA 53 violation that the court has received.
So we'll set it for second final pretrial. That'll most likely, are we looking for an earlier date?
Since we can arraign him on the PA 53 violation today, the people would ask that it be at least 2 weeks out. So
Okay, for
get subpoenas out.
okay. So subpoenas will be sent out and we can do it at least 2 weeks or more.
Not more, I mean, we can do-
Let's try 2 weeks. Yeah, that'll give you enough time for subpoenas, right? The 2 week
2
date?
weeks should, yes.
Okay. So set for final pretrial on
August 3rd, 8th.
August 3rd at 8:30. So it's set for final pretrial on August 3rd at 8:30, and then I'm going to arraign you on the current arraignment, which is a PA 53. You have that date, Mr. Smith, of August 3rd at 8:30
Yes, I have, Your Honor.
for the second final pretrial.
Indeed.
All right, and you're being arraigned on. So, Mr. Johnson, you're being arraigned. You were arrested for a violation of the PA 53.
Right, I don't believe he was in custody, so I don't know that.
Yeah. I think so. You were. Yeah, he was not. He was arraigned. He had been arraigned on. This was on the DV, right? And then his bond was set at 2,010%, and he made bond.
I believe that's correct, Your Honor.
Yeah, that's my. And so he was out, and then he violated the no contact order, I think.
Yes, I apologize that you're talking about the original.
Yeah. So 2,010%, and then he was out, and then the claim is the allegation right now is that you had contact with Ivana Ruiz, and that's why you were picked up on this charge.
I believe the specific part is that he would have been within 2,000 feet of.
2,000 feet. Okay. So you're within 2,000 feet of the no contact order with Ms. Ruiz, is why you're being picked up, is why you were picked up on this date. So you understand that the no contact order means no contact with a certain individual, even if that individual says it's okay, it's not okay. Only I can say it's okay. You understand that?
Yes, sir.
All right. And so that's the allegation of that you were in violation of contact with Ivana Juanita Ruiz, or be within 2,000 feet where she lives, works, or goes to school. And that's the reason you were picked up, okay? And yet at this time, are you requesting, are the people requesting that that violation be placed with the final pretrial, or how are we proceeding in that?
That is the people's request. We would also ask for a GPS tether to be added.
All right, and Mr. Smith.
Your Honor, I'm in agreement as far as the scheduling of the matter. I think it's appropriate and efficient to set it for the same date. I would, I suppose, predictably differ with regard to the request for GPS.
GPS, yeah.
I think it's fair to say that's necessary in some circumstances, but I'm not aware of any factors here suggesting that this is particularly egregious, any threat of any sort. I will acknowledge that it appears the complaining witness is either uninterested or for other reasons not appearing in this matter. I can only speculate, but I don't see that GPS is particularly necessary or helpful here.
All right, Ms. Kachukas.
Our people's position is that a GPS tether is necessary and proper because we have been unable to make contact with the victim to make that determination. Even on the date that this alleged bond violation had occurred, the police were unable to make contact, so we have no way to determine whether or not the victim is truly safe. So it would be appropriate in this matter to have a GPS tether. I understand that it is a financial hardship at times. However, this is essentially 2 weeks. I think that given the short amount of time, I think the financial hardship is so much lesser that it's appropriate.
All right, I've adjourned the violation August 3rd at 8:30 to coincide with the final pretrial in this matter. I am going to add a GPS tether, and you can pick that up at the Ingham County Jail. That's where they put it on, and it'll be with victim notification or zone notification, whichever is possible. I don't know,
We can
Since-
set the address as the actual exclusion zone on the.
yeah,
ordinance.
I think.
I would ask that.
Yeah, I think then it's zone notification and we've been told by GPS that they prefer one or the other to be left with them, okay? So that's why we say zone notification or victim notification, whichever is possible. If you're more comfortable with zone notification, we'll just make it that address. That seems to be the way to go because that gives you an address that you know is the 2000 contact order. And what you're trying to do is protect yourself right now to stay out of that 2000 feet. Okay, I think that's the fairest way to go.
Yeah, I would ask for a zone because we don't have contact with the victim. We can't really set up the victim notification.
So is the zone notification is 506 North Magnolia?
Correct, sure.
Okay. So GPS with zone, I'm going to say zone notification with 50, and it'll be 506 North Magnolia. You should also state you'll have a no contact order, so the zone will be 2000 feet of a place of business. Okay, so place of business, work, or school,
Or home.
or home. Yeah. So, Mr. Johnson, for the next few weeks, you're going to be tracked with the GPS device to make sure that you follow any no contact orders out there. That'll be the violation. The violation will come from them, if not from the person. So be aware. Okay, be aware. All right, we have a GPS zone notification of 506 North Magnolia, and then any no contact with the name of business, work, or school of the complaining victim, and that is Ivana Ruiz. And then, Mr. Johnson, we will email the tether company for the time that will be put on, and that's usually done sometime this afternoon. Okay, be done this early this afternoon. All right. If you fail to appear or you don't appear for the GPS, then we're just going to put out a warrant for you. Okay? All right. All right. Anything else for the record in 2601590, Ms. Kachukas?
No, Your Honor, thank you.
Mr. Smith?
Not today, Your Honor, thank you.
All right, Mr. Johnson, I don't know when they're going to put it on. Tether.
I have to email them.
Yeah. So, so keep in contact with Star and she'll tell you when to show up to get it put on. Okay.
Okay.
All right.
When am I scheduling something else?
Yeah, we set it for final pretrial for August 3rd at 8:30, and we set it for PA 53 August 3rd at 8:30.
Okay, so I get final return.
Yeah, that is an adjourned final pretrial. That's correct, Ms. Kachukas. We set it for an adjourned final pretrial.
Adjourn final pretrial and K53 violation.
Okay.
I didn't do that.
Okay.
I just did this file, so it's- Yep. Okay, and I will email JSG when I'm done with this, because I'll probably have to send them a copy.
All right. So, and will you know when he should go get the GPS
As
put
soon
on?
as I email them.
Okay, all right.
Have a seat. I have to type all your paperwork out.
Thank you, Star.
You're welcome.
Who's next, Ms. Kachukas or Mr. Decker?
I'll refer to Mr. Decker.
Devin Ornelas, Your Honor.
Devin Ornelas. All right. All right, Mr. Ornelas, we'll call your case. We're on the record in docket 2601772. That is People, the State of Michigan versus Devin Ornelas. Appearances for the record, Mr. Decker.
Andrew Decker on behalf of the people.
Mr. Rabat.
Alex Rabat on behalf of Mr. Devin Ornelas. If you could state your first and last name for the record, please.
Devin O'Nellis.
Okay, and Mr. Ornelas, you can hear us all right?
Yes, I can.
All right, thank you. This is time set for a pretrial in the matter. Mr. Decker, how are we proceeding?
We'll be setting this out for a final pretrial, Your Honor.
And is that a fair statement, Mr. Rabat?
Yes, Your Honor.
So we'll set this out for final pretrial for August 3rd at 8:30 for final pretrial. That'll be live in person on the 6th floor of City Hall of Lansing. And that is set for Monday, August 3rd at 8:30. So that'll be your appearance live. Okay, Mr. Ornelas?
Yes.
All right. Anything else for the record in 26017772, Mr. Decker?
Nothing further, Your Honor.
Mr. Rabat?
Nothing further, Your Honor.
All right, Mr. Ornelas, we'll see you on August 3rd at 8:30. Thank you for your appearance today.
All right, you're welcome.
Yeah.
All right, and who did you want to call next? And then Ms. Kachukas, we have, it looks like a nollie on Jewel.
Yes.
But we'll go on the record on that just because there's a PA 53 violation on that one.
Oh, okay.
Okay, so we'll just go ahead and put that one on the record. All right, but who do you want to call next, Mr. Decker?
John Luxon, Your Honor.
John Luxon. All right, and you're the interpreter, sir?
Yes, sir.
All right. All right, let's swear you in. So I'm going to have you state your first name and last name for the record. Yes.
Abner St. Giles.
Okay, and spell them both, please.
Abner, ABNER, St. Giles, SAINT, space, GRLLES.
All right. All right, please raise your right hand. Do you solemnly swear affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communication, so if you got under the penalty of perjury? All right. You just let me know if I get going a little fast.
Thank you, sir. Thank you.
All right, so we're on the record in 26017888. That is People of the State of Michigan versus John Luxon. Appearances for the record, Mr. Decker.
Andrew Decker on behalf of the people.
Mr. Rabat.
Alex Rabat on behalf of John Luxon.
And
say your first and last name for the record, please.
John Kelly Lixon.
So you are John Kelly Luxon, is that correct?
Yes.
Okay, thank you. All right, this is the time set for pretrial in the matter. Mr. Decker, how are we proceeding?
We'll be setting this for a final pretrial, Your Honor.
And is that a fair statement, Mr. Rabat?
It is, Your Honor.
So set for final pretrial on August 3rd at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. And we will be responsible for getting an interpreter here. And the interpreter would be a Haitian Creole, is that correct?
Yes, Your Honor.
Or Haitian interpreter, Haitian. All right, anything else for the record in 26017888, Mr. Decker?
Nothing further, Your Honor.
Mr. Rabat?
No, Your Honor.
All right, we'll see you. That'll be live in person on August 3rd at 8:30, just like today. And we'll have an interpreter here for you, okay, sir? All right, that's all for the record in 26017888. Thank you for your appearance today.
Thank you, Your Honor.
Thank you for your assistance too.
was on Zoom. James, we have Williams in the cloud.
Yeah, McLeod,
Do you have McLeod?
he's on Zoom.
Is that Mr. Harry's on McLeod? If he's here, we'd be ready to go on McLeod. Harry, but-
I have Mr. Harry's, yeah, I have that's, but Harry's on this.
What's the case, what's the case on it?
It's Tavion McLeod, which is 26011817. I'm sorry, I'm sorry. I'm sorry, that's Moltar.
Yeah, it looks like it's,
We have that as Miss Rawls as well.
Yeah, that's Miss Rawls. Yeah, that I
I can see if Mr. Smith is ready on, Mr. McLeod's case.
All right.
If not, you might need to.
think you might have to talk to him. Okay. Yeah. And I don't have Mr. Moltar here yet.
Molitor, I think
We already handled that.
Your Honor.
We already handled that?
Yeah,
Okay.
that was a final free trial.
That's what happens. I think I scratched off the wrong one.
We should still have McLeod, Williams, and Reed. Is Mr. Reed in custody?
I think Mr. Reed is in custody. Did you want to bring him up?
I'll have to defer to counsel because we're gonna need an adjournment. We're still trying to get that police report.
So did you want Mr. Reed brought up or did you just,
I would leave that up.
That's Miss
Your
Rawls.
Honor, but we are ready to go on Mr. McLeod.
Okay. All right, so we'll call your case, Mr. McLeod. All right, so we're on the record in docket 26-01752. That is People of the State of Michigan versus Tavion McLeod. Appearances for the record, Mr. Decker.
Andrew Decker on behalf of the people.
Mr. Rabat.
Alexander Rabat on behalf of Tavion McLeod, who is appearing via Zoom for us today.
Is this your case or is this Mr. Harry's or?
This is Mr.
Okay.
Smith. I'm standing in because I didn't know how long.
All right.
It's gonna be busy.
All right. And so Mr. Harry's, your appearance for the record.
Assistant Public Defender James Harris here supervising Mr. Rabat.
All right. And sir, you are Tavion McLeod, is that correct?
Yes, sir.
And you can hear me all right, Mr. McLeod?
Yes.
Right, thank you. This is the time set for a pretrial in the matter. Mr. Decker, how are we proceeding? Would you like to defer to Mr. Harris, Mr. Rabat, or covering for Mr. Smith?
We will just be setting this for a final pretrial, Your Honor.
And is that a fair statement, Mr. Rabat?
It is, Your Honor.
Okay. So set for final pretrial for August 3rd at 8:30. And Mr. McLeod, that'll be live in person on the 6th floor of City Hall of Lansing for August 3rd at 8:30. You'll get notice sent to the Dakota address. Is that still a good address for you, sir?
Dakota, that's where I used to work.
Oh, so I just want to make sure, I want to confirm that we're sending it to the right, Richwood.
Yeah.
Is that Richwood address still a good address?
Yes.
Okay. All right. So that's where you get your notice will be sent to for the August 3rd at 8:30 date. That'll be live in person. All right, sir?
Alrighty.
Anything else for the record in 26-01752, Mr. Decker?
Nothing from the people, Your Honor.
Mr. Rabat?
Yeah, Your Honor.
All right, you should be all set, Mr. McLeod. Thank you for your appearance today.
Thank you, sir.
Smith, do you have any update on Reese Williams?
But I don't think that that's on. Your mark, yes, I'm not sure.
All right. Yeah, that's a. All right, I have Mendenhall, Reed, and Williams. And then we probably should go on the record on on Jewel, just to acknowledge that I'll dismiss the PA 53.
Like Reed should have been in Poly.
Oh, Reed should have been on Polycom. Yeah. All right, Mr. Decker, what case did you want to call next, or did you, and just let me know if you need a break to talk about some witnesses or cases or what have you.
Not yet. Okay.
I don't. Do we need this to read?
Did she say it's ready?
He should be placed on Polycom and he hasn't
Okay.
been, so we can bring him up.
Okay.
Yeah,
Gotcha.
but that's a Rawls case. I don't know who's covering for Rawls.
Mr. Smith. is
Okay.
gonna be on that case.
Did you want us to bring up Reed?
I think I can just go down and talk to him after.
All right,
It's a unavoidable adjournment.
all right.
Well, come to think of it, I do want to address bonds, so we might have to.
Yeah, let's bring him up. That's just a better
It's gonna
safe.
be here in person.
I'm not certain.
He may not, but
He was on our list to be on Polycom, so I don't.
oh,
know.
okay.
And they probably
No,
can get him in.
he won't be
because-
here. If he's in Polycom.
Okay, so he's not.
So-
Ready to go. on
You'll have,
record.
you'll have to call the jail.
So you might have to talk to him, or we'll just wait. We can wait for him to be placed on
We
Polycom.
might have to dial it.
You'll have to dial him in. Or not.
I can pull up what post he said.
Yeah, I don't think we.
Usually Judge Ward doesn't take too long.
Yeah, I've never done that.
He's in.
So it could take a long time because we don't know how to do it.
He's in post 2. Ms. Schmidt, do you know exactly who is called at the jail?
I can call our new contact person. Let me find her.
What's her name? I can't even remember her name.
Lieutenant Jen Urban.
Urban. I should remember that name.
Court officers should have a phone at their desk.
Will you mention this?
No, probably not. Do you want me to go in the office and give them a call?
Yeah, let's see. If we can get them on Polycom, that's
All right,
fine.
let
Or
me
they,
make a call.
yeah,
Yeah.
because everything's a little bit kind of
Weird name.
messed up. Yeah. He was probably on Polycom at 9 and we were not.
So are we actually?
I shall return.
But Drees Williams.
I don't think we have Mr. Williams here.
Was he here earlier?
We have, he has not appeared yet, but if he was coming on via Zoom and tried to come on time,
Right.
he wouldn't have been able to.
Yeah. I'm reluctant to bench warrant anybody for. All right.
We did not know. Just knew what happened.
And has Paris Mendenhall been here yet? That was set for 11.
Which
We
one?
had no idea. Just knew what happened.
Paris Mendenhall, her plea at 11.
Right way.
I have no information. I don't know.
And all I have is Cornish on that one. So Mr. Smith,
Probably.
have you seen or Paris Mendenhall? That's the 11 o'clock. Is that yours or, because all I have is Cornish now.
I believe that's assigned to Mr. Harris, but
That's all right.
All right,
depending on whether they're present, they could stand in.
right.
Are you just wanting to adjourn Williams? Or
I think at this point, yeah.
okay, we could go on the record for that.
On Williams, just, I'm kind of inclined not to ask for, not to do a bench warrant on anybody because this morning we were kind of,
Strongly inclined to resist.
yeah.
The request.
Because I didn't know what we were doing, so.
Let's say yours not bad.
All right. Let's go on Dries Williams.
Yeah.
All right, so we're on the record in 26-00525. That is People of the State of Michigan versus Dries Williams. Appearances for the record, Mr. Decker.
Andrew Decker on behalf of the people.
Mr. Rabat.
Alex Rabat on behalf of Mr. Williams.
Right, this is the time it's set for a pretrial in the matter. I'm sorry, yeah, it was set for pretrial in the matter. This was set for 9 o'clock. It is now about 11:13, but we did not have power in the building for, I'd say, the first couple hours, 8:30 to 9:30 to 10:30. And if Mr. Williams was to appear via Zoom for his pretrial, which is his right, and which he also was given notice that Zoom was potentially capable, that there was no way to get to Zoom because there was no power. With that understanding, Mr. Decker, how did you want to proceed today?
We'll just ask for an adjournment of the pretrial, Your Honor.
All right, and then Mr. Rabat, that you understand, that's a fair statement, is that correct?
Yes, sir.
All right, I do have evidence that Mr. Williams was being evaluated at arraignment and he was placed on bond. One of his bond conditions was no contact with the complaining victim, Rachel Fitzpatrick, who I think was a nurse at Sparrow Hospital. He has failed to appear in the past, April 6th and May 4th. We have on that he was hit by a car on April 12th, and then he was held without bond by 54B. And so with that I placed bond. A request was made to place bond, so he's collecting if he was incarcerated. That's my understanding. I don't have a problem with adjourning this because of the circumstances. But Mr. Williams obviously has some failed to appears, and so if Mr. Rabat, if you're able to have contact with Mr. Williams based on this case, he's still under the current bond conditions.
Okay.
What I'm afraid of is that we're going to get a bond violation based on some of his prior activity. But I mean, that's just so he knows. And then we'll reset it for something within 2 weeks. Okay. So we'll reset the pretrial.
August 3rd at 9:30.
Okay. For August 3rd at 9:30. Typically, Mr. Williams would be facing a bench warrant concerning this matter. And because of his two prior files, it would be issued immediately. Because the building was down and Mr. Williams could have attended via Zoom, then I'm not comfortable doing a bench warrant, but those options are available next time. All right, so we'll set it for August 3rd at 9:30 for pre-trial. Anything else for the record in 26-00525, Mr. Decker?
No, Your Honor.
Mr. Rabat?
Nothing further, Your Honor.
You should be all set, sir. Thank you for your appearance today on that file. So, Mr. Harris, are you on Miss Mendenhall?
I am here on Ms. Mendenhall, Your Honor. I actually just got off the phone with her. She indicated she ran into a bit of a complication on her way here. Should be here in about 15 to 30 minutes, and apologizes for being late.
All right. So, and then we have a little bit of time because we're waiting on Mendenhall and Jack Reed, which is the other, may or may not be on Polycom.
Does the court not want to go on the record on Jewel?
Yeah, let's go on Jewel.
I don't know that he's still here.
Yeah. He may be, but I don't think we're present regardless. Let's put this on the record.
Yeah, this is just only because there's a PA 53 along with this, so.
Yes, and I didn't realize it was was it scheduled for a PA 53 or just scheduled for?
I think it was just scheduled. It was set for final pretrial.
because we did not subpoena anyone because it wasn't set for a.
Yeah, and there's no,
That email, whatever that you're.
I think, under the circumstances, it's resolvable anyway. I was not aware of PA 53 actually.
I'm not even, I don't have a PhD degree at all, actually.
yeah, I think this one, that's the, who, that's your note, but who'd you,
I wrote that only because.
no, I don't know. Email was the GPS was being turned
Oh,
off.
yeah, I'm sorry. Yeah, the GPS is gonna be shut off.
But-
Not 53.
Oh,
So.
so
I
it's not a
got
PA.
it. No, I got
Okay.
it mixed up.
All right.
This was about the,
All right, and with the dismissal, they were gonna shut off the PA 50, they were gonna shut off the GPS by July 21st, which is tomorrow.
Oh,
And the case
wonderful.
is being dismissed, so we don't have anything to worry about.
Sorry about that.
Okay. So, but that's good. This is belt and suspenders, which is, all right, so.
I made myself. a
So
note.
20, so we're on the record 2601-620. I'm in possession of the nollie pros on the matter. I will sign the nollie pros and place it in the file. And we can give you a copy for your records if you need one, Mr.
I'll forward you this
Mr.
email so
Smith.
you have it. for your
especially
records.
for purposes of getting the GPS removed.
Yeah.
I'd like a copy.
And my understanding is they're gonna turn off the GPS tomorrow.
Right, but he still gotta get it off. Like,
What's that?
he still has to get it taken.
Oh, he's got to take it off
Otherwise, it's a felony if
beforehand.
he takes off.
Yeah.
himself.
You'll do that today.
Yeah, all right. That's a good point. All right, so I'm gonna sign and then he can get it, Mr. Jewell can get it taken off. We'll contact the private agency that does the GPS and tell them that they're removing it because the case has been dismissed.
Go food out.
He turns up.
Oh, okay.
I bet you.
Mr. Reed is at 30th Circuit Court right now. Regarding Mr. Reed.
So there's Jewel.
Thank you for finding it.
So Mr. Reed's in circuit court?
Yes.
Are we just adjourning that?
Oh.
Mr. Smith?
So he will not be appearing.
That's unfortunate.
Darn, I hate when
We
that
can
happens.
reschedule Mr. Reed for the pretrial. I mean, if he obviously has a conflict because he's in circuit court.
I think the plan was to adjourn anyways, because we're still trying to get discovered.
All right. And depending on what happens to him in circuit court, that may,
Oh.
all right,
That may take care of.
that may take, yeah, that may,
I don't know that Circuit Court is aware of this file, so I'll reach out. to them.
all right. All right, so Mr. Rabbi, are you handling Mr. Reed
Yes, Your Honor.
and Mr.
I will email.
Chevalier.
Chevalier?
Gene.
You want a copy of this?
For my client, yes.
Yeah, I'll email it to you.
All right, so we're on the record in 2601-609. That is People of the State of Michigan versus Jack Reed III. Appearances for the record, Ms. Chevalier.
Good morning, Your Honor. Grace Chevalier for the people.
Mr. Rabat.
Alex Shabbat for Jack Reed, Your Honor.
All right, this is the time set for a pretrial in the matter, and I'll make a record and then allow either of the parties to supplement the record. This was set for pretrial. They're supposed to put Mr. Reed on Polycom. We have information that Mr. Reed is addressing another case in circuit court at this time, and therefore my understanding is we're going to be adjourning this pretrial for a second pretrial. Anything for the record, Ms. Chevalier?
Nothing more for the record, Your Honor.
Mr. Rabat?
Nothing further, Your Honor.
Okay, so we'll reset this. We'll reset this pretrial
August 3rd.
for August 3rd at 1:30 and then
9.
at 9:30. And then Mr. Bott, you can let your client know what we did here today, or yeah, it's because we've set it for August 3rd at 9:30. We've reset it mostly because we have a conflict. And so if they try to join earlier, which they may have, we obviously were not online. We had no power then. So, and he was set for 9:30, so he was set for 9, so he could have run into that problem.
And you said August 3rd at 9:30, correct?
Correct. August 3rd at 9:30, we'll reset the pretrial for. Anything else for the record? 2601-609, Ms. Chevalier.
Nothing further, Your Honor.
Mr. Rabat.
Nothing further, Your Honor.
All right, we're all set on that file. So I think we just have Miss Mendenhall left. Is that right?
That might be the case, Your Honor.
All right, because we had Hayden and it's being taken care of, and Suarez and Green and Hall and Olson. All right, so I'm going to put those aside. We have a civil one too at 2:30. Pennsylvania State versus Anthony Davis.
Also, should I have brought that up, or is it not necessary?
This is the sensing.
Are
All
we
right.
not going on the record, and I'm not scheduling it?
So Miss Kachukas, you said on those on the files we're not going on. You're just going to submit either a nollie or a
stip in order to
Okay,
adjourn.
perfect.
Oh.
I believe we're looking at final recalls in October.
Okay.
So it'll be in the stip order.
Okay. All right.
I can write it somewhere.
All right. So we should get stipend orders or nollies on those ones the ones that you marked.
Put that jury trial on my schedule.
Which one?
You know.
So if they try.
Yeah, they took it off.
Try and sort of, if you need to know.
Yeah.
You just make sure. Cassidy, am I scheduling a jury trial for Hall or no?
I thought we were setting it for a final pre-trial first.
Oh,
Or I guess
That's the notes I have for Paul, yeah.
okay.
I think we're setting it for a final pre-trial and then pre-trial. I don't know if you set them both at the same time or not. It's work.
We usually do a final pre-trial and then we do the jury trial.
Okay.
But it was taken off. My docket was taken off. The Hall case, the jury trial case.
Hall?
Yeah.
All is set for jury trial.
Gerald Hall is set, for pre-trial. We had a Hall for, who did we have?
There were.
Set for jury trial.
Well, I
Yeah,
had a note that they were going to set it like in
yeah, Hall
October.
was the one where it was set for a final pre-trial where the complaining witness likely wouldn't need to appear, and
Okay.
then I guess a jury trial after that.
All right. So you're talking about Gerald Hall.
Yes.
So I
You're
should,
thinking Scott maybe?
Just
Yeah,
Leroy Scott?
Leroy Scott and Lene Quilly White were jury trials today that were skipped to adjourn because of
oh
some
yeah, no, yeah,
new
yeah.
evidence and
Okay.
other matters.
So Gerald Hall is going to be it's going to be one of the ones that you're going to sip in order on.
Yes.
Okay.
I'm just gonna disregard
Yeah.
So we just have,
So we just have Mendenhall,
okay.
right? So come get me when Mendenhall's ready, and I'll look at the. So come get me when Mendenhall's ready,
What's your honor?
and then I'm gonna look at this sentence and then.
All right.
And then her note, Marquita's note.
Yeah.
Is that Marquita?
Well,
She took it down at probation and they said.
no, I didn't take it anywhere. Kathy brought it in to
I actually
me
didn't
and
ask for it.
said it was from Marquita.
Oh,
Some last week, so I think I just, that was at 10:40.
Yeah.
So I'm guessing we already did that.
She's doing all that.
She's not.
a little more.
Nothing.
Seems off, and I asked.
I'm doing
her.
it.
I was like, well, she worked last.
She may be seated. She worked, well, she wasn't here Thursday and Friday. because of snow.
Been
Judge
down
Simmons
twice. I know she's
Oh.
frustrated down.
She's gonna be, is she not?
She,
I don't know.
I know she has
Skip my
major
ex-
heart issues.
Right.
So this is the last place she needs to do that.
Can I
Quite
shit
honestly.
And she, the benefits she has.
So we just have mental health for the morning
Right.
docket
Yeah, I
left,
think so. And that's just, should be just.
and then what's the afternoon docket look like?
Yeah, I think it's just, I think it's just like a civil case and then sentencing where he was denied a public defender.
So it's either per se.
Sentencing or what?
Denied for PD, so it's gonna be proper.
Wait, I thought Martinez. Oh, no, we don't have anyone listed.
Yes,
I just saw
he is.
Smith because it was assigned to Dan Smith and I was confused.
Gotcha, yeah, it's, he was previously denied, so he's representing himself today.
Folks, I will feel.
I was gonna say, can't they just like apply again or?
But sometimes they're like, oh yeah, I forgot about the fact that I remit $2,000 a month to, you know, my family, wherever. Sure. Easy. If you're.
Courtroom number 3.
Right, so I don't know how that's.
You'll see what's happening. I could probably Zoom on their own circuit.
There's also an afternoon sentencing.
Oh, okay. Well, I mean, do you still need me around for anything to cover for anything?
Are you comfortable with sentencing? Let's check the screen to see. So. we don't really have-
So
Yeah.
after this, there's nothing.
Yeah,
for
I mean,
me
as long as you don't
left to do in the courthouse today.
Okay, happy to handle it. Oh. Is it Martinez? Yeah. Okay. Oh, it's just- Do I foster recoveries? It's just-
Yep, that's something you do have to ask for.
It's just the.
But yeah, we just asked for the standard cost recovery fee of $125.
Just. Oh, because it's. Plead guilty. Or he did. Plead guilty.
Yeah. No crash and no restitution.
Okay, so it's literally just, so that is counted as restitution, though, is this?
Yeah, just the cost recovery.
125 cost recovery.
Is there a PSI for this afternoon? Sunset.
I had sent it to Dan. I can send it to you.
That would be appreciated. Thank you. It's just.
Because we never know who it is, so.
Correct. Yes, that's still the best practice.
Let's see.
I'll tell him then he needs to start uploading them. It's just first initial, last name. Hang on.
Hang on, I didn't hear that, so just a second.
No worries.
Say it again. It was,
It's first initial, last name at Hingham.
got it.
That would work. If you.
Interpreter request has been sent.
Okay, sounds
Thank
good.
you, my
Do
dear.
I need to link that? Or is it-
You sent it to, what's her name, right?
Nice.
Esmeralda?
Nope, that goes to Bonnie.
No,
the
it
same
does not.
felony.
It does not.
Felonies goes to Esmeralda.
And you'll still be. in.
Oh, okay.
Yes, this is
All
not
right.
a felony, so there's.
Okay. Sorry.
That's okay. I got you.
I was reprimanded last week, so.
Oh, I think I finally got off the reprimanding list and just when I think I'm doing better. I'm like, and it's just a small little things. Approval, thank you for information. Some for the correspondence. Yes, I gave it to your district with plus some. All righty, that's all done.
I don't think I've been
I
in here
sent the
for a
thing
while.
over for the one gentleman to have it
He's
removed,
not
one to
seeing
have it placed.
Yeah.
So he's gonna be with you next. Placed on
Yes.
him.
So
And you've been here.
We are on the roll.
Yeah, I was.
Yeah,
in
we
our-
just
Hang out and work.
Yeah, I was like,
We actually might be done
before
before lunch.
Which is funny,
Which
because
is
the way
crazy
they
when,
started off, it
you
sounded
know,
like you and I
big
were
delay.
going back and forth every other week almost.
Yeah.
But I'm okay with it.
Well, I got my paper filled out just in
Perfect, I'm
case.
okay with that.
Yeah, it's easier to learn.
I don't know who you got this afternoon.
And when the
so-
judge
Because in your
shows
Yeah,
CC.
but we only have
Mhm.
a sentencing and a
He knows me, he knows me.
Uh,
Mr.
general civil pretrial.
Chevalier.
So honestly, we probably don't need it.
Yeah, you got one of the probation guys.
Dan, the wrong name all the time. Smith, the wrong name here and there.
My gosh. And all of these I will mail out as soon as I can get actual regular envelopes, because these are not civil.
It's like this cup. Nope, just go for it.
Wait, what now?
You're like, I just wanted not even.
Oh, yeah, they're civil.
Oh, in here. I can go grab you some. How many do you need?
A whole lot.
The cookies.
I got it.
Once you get used to it, it's not hard to say. It just doesn't look anything.
It does
like
not
it.
look like anything.
Should I bring a box of the non-civil?
You might as well bring a box out here because
Okay.
he needs to know that it.
Go on then. I believe.
Defendant self-represented.
Stated that he didn't want to do the plea. They wanted to.
Are you talking to me? I'm sorry.
Rave on them now.
Okay.
It was originally just a plea. Flores said he didn't want to be used, so we decided to have a new person.
Okay.
Judges
Shouldn't be
All right. If he hasn't. So recommendation is alcohol substance use disorder. You can't do immediate sentencing on a victim case.
Right, this was the thing. Last time we had the complaining witness here and she was over Zoom. But then Flores indicated he didn't want to do the plea over Zoom, so we.
Victim wants to subpoena for this case, she's, you're not here.
Yeah, alright, that's unfortunate. Yeah, the previous offer was just disorderly with promise to pay restitution and judgment. No, for Jay.
I'm not pulling that offer, obviously, because it was set for plea date. I'm hoping Dan did what he was supposed to and asked for permission before doing that. I don't think he did,
I would
but I
hope
can't pull
so.
the offer.
I can't
Yeah, I'm
necessarily
not somebody
say,
who's going to pull the offer. I think it may be appropriate for presentation, but it should not.
yeah, I can't say what happens in Dan Smith's head in your office.
And I can't say what happens, what Dan Smith does, because I can't rely on the notes.
Well, that's unfortunate. That is why. I thought when I just have my Word document and I have everything in there and then I just copy paste it
Oh.
from there.
No. It has nothing to do with whether or not there are notes. It's whether or not they're active.
Well, see, to that I would say, if anyone ever goes, well, the notes are accurate, I go, well, these are the notes. I have.
So I'm scared of what's gonna happen.
It doesn't sound very, it doesn't sound like
That's who's covered. If I can have faith in who's covering for me, then it's not an issue.
You got Andrew Decker, what do you mean?
Covering attorney is the problem.
You gotta
I'm
have
the
a
one
P number for that.
consistently
Yeah,
in
yeah.
here, but.
You probably have a just reference going on.
I
Just
had
for you.
to figure out what was it 2 weeks that I was out.
Maybe?
We still was out and thankfully Bart was on who said it. I'm like,
Oh, yeah,
if
you were.
Dan still said, yeah.
Really gotta come to court.
Turn here first.
I mean, I think you were here when the situation happened.
You were here. Yes.
Yes.
I think I'm assuming you know what happened.
I
You know which one
I
it
know
is.
the
So,
same situation.
There was a case that
Andrew,
Dan
I'm
had for like
Oh.
9 months.
Oh,
Yeah.
right.
And he was
Well,
asking for an adjournment
when
because he had the wrong phone number for the client, but had 8 months of previous contact with the client. And Judge Flores said, you're certainly living up to your reputation.
Oh, I remember that.
Yeah.
Yeah,
Remember-
that's what it was.
That's
from.
what it came from? Oh, I didn't.
That's you were here.
Interesting.
I was watching. the video.
Yeah, because it was set for a jury
Because the
trial.
whole
Yeah,
room got
I remember that,
quiet
'cause I
when Judge
remember him,
Flores
like-
said that.
Yeah,
And I
because I
was
remember
like,
talking to him
what
about it
just
and he was
happened?
whatever, but I didn't
Yeah.
realize that was.
The
it was all
silence in the
from
courtroom
that.
after Judge
Oh,
Flores.
It was
That's
deafening.
one
It
of
was deafening.
that's the most recent one.
Oh, interesting.
May I ask what that reputation is that he's living up to?
He had no idea apparently.
I don't think I can
You're
because
fine.
Yeah.
part of the issue is that he said things he wasn't supposed to.
Okay, okay.
And I shouldn't be saying the things that he's not supposed to
Fair.
have said.
So
We need to.
I was just very
related to, but-
confused that day. I was like, what is going on?
So what I'm hearing is this sounds like it might be. Situation.
I don't know that we're.
Okay. Not there yet, which is good. I hope other people do not approach it. 'cause
Considering
that's-
once we got the email when he was fired, that
I think this was the one you
left
helped
him focus on the
align
board.
with last week.
We got an email. that
Ring a
said
bell?
we're asking
Oh, I
for any preliminary
It was the
recommendation
one
before
that
any
went
changes to class
last
about it, was sent directly to John and Dickey.
Okay. I'm pretty sure you helped him. Okay.
Yikes.
Which
That was the other guy, that wasn't.
That was like the
Was
first
it
month
sent to
that I was an intern at our office.
JSG.
I'm still here wondering what happened to Susan.
I'll send it now.
Well, she could send it. She just
Like
was
a lot of
curious.
jury
And I was
trials.
like, I don't.
I don't.
Yeah.
Not. See, that's the problem. I
There
never
was
know.
one, like the,
Oh, the person at
That's
54A.
okay.
yeah,
I have no idea.
yeah, she used to be like
Okay.
the HR person here.
All
And
right,
also was the one who
I'll
always
just have
like.
her do it.
coordinated
Just tell him to
jury.
do it.
Yeah,
Just-
no,
just
he's
say,
not here
I
anymore.
don't know what he did after I walked out.
4 or 5 years.
And I
and
don't
one day
know
come
that
and I'm
that
like,
was on the
"No,
list.
It
I
wasn't on the
didn't
list to
I'm
send.
like, wow, it's like, yeah.
Okay.
So.
No
All right.
one knows what happened or why or anything. Just one day, chief judge walked over to the security desk when I need an escort. I need someone to help me escort Susan out. And then Susan was gone and never came back and no one, to this day, still no one knows what happened. And I'm like, Susan was, Susan was friendly and very kind of chill, nice person. So what happened there?
And I guess technically we don't formally know that that's the reason that Dan is on screen now. But
Is it by
but
the court? or
the
by
timing is what?
It's by the court or the-
We decided to schedule it. Unless you get banned from a courtroom.
Yeah.
Which
that's what I was saying.
Brodowitz was in fact banned from
Yeah.
courtrooms.
Banned from Simmons, and I think also Buchanan. I don't know if he was formally banned from war.
No.
Dishonesty.
Oh, I was like-
Yeah.
Okay.
Yeah, that's, I've been asking him, so. Just think.
It was a mountain of things, but I
Generally, dishonesty is usually the final straw.
yeah, I don't think he was ever formally banned from war, but Shelley had said numerous times if Brodowitz ever steps foot in my courtroom, he is not going to be
And
in
it's Shelley's
the
court- it
courtroom
was Shelley's
anymore.
courtroom.
And he's like, if he steps foot in that courtroom, he will not be in that courtroom shortly after.
He will not be anymore.
So no. Shelley has said numerous times that Shelley will cop a misdemeanor or a felony with certain people.
I'm well aware.
Happy to pick up the charge.
No, I'll throw it down. I don't have no
I'm
problem.
impressed that she retired without. Well, I actually can't check. I'm not gonna go searching to see if she.
She was very proud of how big a company her file with HR was back in the day.
Are you a student? Where at?
Michigan State,
Oh, okay. What year are you?
3-0.
Okay, okay.
Fun.
You?
I'm a 2L.
Okay. I was like, you're a little familiar, but I had no clue who you were at the same time.
Yeah.
Getting ready for the bar exam then?
That's a
Not till-
future,
not
that's
till
that's
next
a future
summer.
me problem.
Sure.
You've got 8 months.
Yeah,
I was gonna say, that's like a spring problem.
yeah, like
wait
I'm
till
not thinking about that yet. Pause, I'm still trying to get to the summer.
Wait till 3L exams are done.
Yeah,
Then,
that's a
Yeah.
future me problem.
So
Fair and reasonable.
before 3L exams are done, by the way, if the timing of that.
we'll see. I don't know. According to Jurgen, Crim Pro professor, he was like, don't even think about it. He said, he was like, don't even think about the bar until after you take your exams, take a little bit of time off, and then you do your study.
Well, yeah, that's because you're, I'm sure. you
No, because
blow
that man
through
is a
that type of
genius.
stuff.
He is so smart.
He's very intelligent.
He is, that man, like, he was like 100 in million. Like, he's
100 million.
100 in million.
That's why we're lawyers.
Yeah.
No, like,
Listen, I was a chemist before I came back to school. I like to think I can do a
That's
little
a
bit of math.
So we have a chemist studying law.
No?
Yeah, I mean,
And
I
what
And I'm
kind
not
of
getting into patent
chemistry
prosecution.
are you particularly pursuing?
I'm not.
And may it be with a Walter White or other such.
Alex, you have to cook.
I have to cook. This is news to me. No, I spent about 8 years prior to coming back to school, doing a lot of like compliance, regulatory stuff, and consulting for like cannabis companies.
oh,
And now you're sick of chemicals.
I'm sick of the industry for sure.
Yeah.
A lot of people in that industry don't know how to be professional. And it's a weird space to navigate having a professional degree and trying to be professional with a bunch of hippies who
See, that's the problem.
Yep.
Is now you're
look at things very differently.
now you're trying
My
to
Orgo
this is the
professor.
problem. Is that now you're trying to get a professional degree to be with a bunch of us. And as I'm sure as you can tell from some of our interactions, a lot of us are absolutely not
No,
as
you haven't met
professional as we
Seamus.
probably
You're a
should be.
basket case. That's okay.
Now, my Orgo professor, it was like 2 weeks before our second Orgo exam. He's like, now I'm gonna give you a hint about your exam. There's going to be something on it that is, you're going to have to analyze the synthesis of a popular party drug. And we're like, it's not a party drug. We were literally going through different party drugs, determining the synthesis for each, and we're like, basically what we've learned.
all right.
All right, you can be seated.
I'm up.
All right, so we're on the record in docket 26-00275. That is People of the State of Michigan versus Paris Mendenhall. Appearances for the record, Ms. Kachoukis.
Thank you, Your Honor. Cassidy Kachoukis for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Paris Mendenhall, who is standing to my right. Ms. Mendenhall, if you could please state your first and last name for the record.
Here's me.
All right, thank you. This is the time set for I think it was set for plea today. Ms. Kachoukis, how are we proceeding?
Thank you, Your Honor. It is my understanding that we are proceeding with a plea today. It's my understanding that an offer of disorderly person has been extended. My notes do not reflect which disorderly person charged, so I'll have to defer to Mr. Harry's as
right.
to which one was extended, and I can provide the PAC code once I have that.
All right, so it's an amended count one. It was the plan. Count one of disorderly person. Is that a fair statement, Mr. Harris? And then which one were we going under?
I believe it was I believe my understanding and my recollection of the offer from my notes, Your Honor, was the disorderly person jostling with a promise to pay restitution, if any, and a Killebrew to no upfront jail. I'm trying to recall if a pink sheet was previously done. Part of me says maybe, but I don't know.
I think we
if one
addressed it,
was
but I don't know if I don't know if a pink sheet was actually done on it.
understood.
Do we have a number for restitution?
Yes, Your Honor. The number that was, I believe, agreed to was 8603. I can fill out a pink sheet while we're taking the plea,
All right.
and I have the PAC code for disorderly jostling.
Okay, what's the PAC code for disorderly jostling?
750.167 1L.
1L.
And just to be clear, because Mr. Harris referenced the Killebrew, it is a sentencing agreement. Our office that no longer uses the term Killebrew because this case Killebrew references both agreements and recommendations.
Right.
And this is an agreement.
So this is an agreement to no upfront jail.
That is my understanding.
And is that your understanding, Mr. Harris? This is punishable by 90 days or is it 92 or 90?
I think it's
90 days and or $500.
Yeah, and or $500. And then if I was going to do something different from the Killebrew no upfront jail, you'd have the opportunity to withdraw your plea. Do you understand that, ma'am? Is that a yes?
And I believe, Your Honor, I'm sure, I think the complaining witness may have been here at the previous court
I think
date.
she was.
How.
Stephen Tamaka?
Yeah. However, they don't seem to be here today, so I believe we would need to set this for sentencing if the complaining witness wants to make any statement.
That shouldn't be an issue. I'm probably going to refer this to probation anyway. So
understood.
90 days and or is it $100? $500. And that's your understanding, Ms. Mendenhall. You'll be pleading guilty to disorderly person. It's punishable by 90 days and or $500. There is a restitution amount of 8603, and there is an agreement between Mr. Harris and the people of the state of Michigan to no upfront jail. If I was going to do anything different from that, you could withdraw your plea. Do you understand that?
I do have a question.
Sure.
So I'm going back on probation?
You may go back on probation. Okay.
I literally just got off probation. Just got off of it like 2 weeks ago.
But then you may not be put on probation.
I realize, Your Honor, this is putting the cart before the horse a bit. I would certainly be trying to make the argument for a non-jail, non-probation sentence.
Right. With the complaining victim, it has to be contacted.
I understand.
You know, that we could go to immediate sentencing, but then
we would need the complaining
we have to come back for the complaining victim, unless the complaining victim okayed this plea offer, and I know Ms. Kachukas is just covering. So
even if the complaining victim, even if the victim did okay the plea offer, people's position is she still has a right to speak at sentencing.
Yeah, she does.
There's nothing in the notes that suggests that she has waived that
It's
right.
a man.
Or I apologize, he has waived that.
Yeah. And then we can confirm the restitution amount, I would assume.
So I would believe we would need to get this set for sentencing. I would make the argument that I don't necessarily know if a PSI is necessary, but I would leave that up to the court's discretion.
Ms. Kachukas. Without talking to the victim or seeing anything, I think you would know.
Correct, and I don't see what harm can come from doing a PSI to begin with. Just make sure that there are no rehabilitative rules that need that.
I'm sick. I have brain disease. I have not been using drugs. I'm trying to get my life.
So, Mr. Harris, did you want to talk to Ms. Mendenhall for a bit, or did? Because because it appears that she's gonna go to probation and be,
Yes.
and so if
I can talk to her for a brief.
all right. Because we can set it for trial too.
I think that I'm
That
not
might-
sure if I'm
like-
comfortable with taking the lead at this point.
Yeah. Well,
And this is an offer that I wouldn't have extended to begin with. Because this offer
don't-
requires approval.
yeah, and I don't
And I
know,
don't have any information that suggests that approval was obtained.
I don't know who. July 20.
I believe this was still Mr. Smith.
Yeah, I think it was Mr. Smith. All right. Well, we'll see that this plea, this may be set for another hearing. Not a bad idea, probably. Since we have some consistency now. Judging by Ms. Mendenhall's reaction, I think we can set it for probably jury trial.
That,
Yeah,
if it needs to happen.
yeah.
Um,
You know how much you like jury trials.
No, I don't. Let's see how far out though we are.
Or just the court, has the court already provided Mr. Martinez with his PSI? Not our office, Mr. Martinez, for sentencing this afternoon. I apologize. Because he's self-represented.
I bet you he hasn't got it yet.
Okay.
So we'll make, so the sentencing this afternoon, Mr. Martinez probably needs his PSI because he hasn't got it yet.
I would print it off just in case.
Just, yeah.
We'll have 2 copies just
Yeah,
in case.
just in case. Because I bet you he hasn't seen it.
And is I'm also scheduled to be in ward at 1:30. Is Your Honor comfortable with Mr. Decker handling the sentencing if I'm in a separate room?
Absolutely.
Okay. I believe Judge has a arraignment to do first, so I'm hoping that she'll handle that and I can stay in here, but
If she not, we know where to find you.
yes.
I
Precisely.
can tell you in a second what we got. So-
We have that one sentencing this afternoon, and I think we have a civil pretrial.
Jury trial would be September 14th.
Well,
We
I
have a
probably should
right-
pause on filling this out. Well, you could keep it in the file just in case it doesn't.
Yeah, I mean,
conviction, and worst case,
yeah,
shredded.
yeah.
We have the arraignment at 1:30.
I think
So-
there's also a probation violations at 1:30 though, right?
Yeah.
Okay.
Do you have to be in there for those?
For the violations, I do, but for the arraignments, I don't.
Duluth.
Did we find him again? Wasn't he in bench warrant status?
I have no clue anymore. Hey, how'd you like the one from Friday? I'm glad I told her. I says, did you read that email? She's like, what email? "The
Thank
one
you
from
for
Paul
telling
City."
her. That's why
She's like, what do you mean, Goodman? And she's like, what?
I've never seen attorneys get on a Zoom so quickly.
I never see my judge fly off the bench so fast. I'm like, you want me to run downstairs and see if he's
She's
still
like,
here?
no, I'm.
And she's like, "Phew." I'm like, all right, grease lightning, there you go.
I told Miss Tusko, she was like, oh, so I get to do that when I'm on the bench. We had
she was not
we had 2
happy.
defendants playing musical chairs on jail phones, or they are alleged to have been playing musical chairs on the jail phones. There has not been a conviction yet for contempt.
Mind you, the one that was
For Mr. Goodman,
upstairs.
he got a very, very generous plea offer. To resolve 3 cases together with 2 misdemeanors, down from a 20-year felony with as a half 4.
Oh, it's pretty good.
And he specifically told Judge Ward, I hear you loud and clear. 5 minutes later,
Just allegedly.
He's alleged to have been on the phone.
He's
As
allegedly
Mr.
on the
Sark,
phone.
hear Mr. Sarks tell it, these are just allegations.
not listen
Mere
to
allegations.
voicemail. She should have played it a little longer. She could have heard the lady saying, this is daddy. Talking to a child or something. Yeah. Did you play it all the way through? Did you hear that part?
I didn't hear it all the way.
Yeah, I played it all the way through. I'm just saying.
We're on vacation
alrighty.
in Germany.
I didn't realize that Judge hadn't
Yeah,
listened to it until she said, I haven't listened to this yet. We're gonna listen to it together. I was like,
We're gonna listen to it together. That was iconic.
it's that
How did they
particular
get back
type
to
of
the
hearing is the one that
States?
makes me a
No,
little
I think
sad that
these,
Judge
this is
doesn't
on
stream.
Reddit, so they
Okay.
could be in Europe.
She was
But-
very,
No, they,
very well behaved.
I'm just laughing because he's got a mustache.
Very well
Yeah.
composed.
Well, he's got the look.
Except
It
that's better than
definitely
I
does.
Yeah.
Yeah.
And then the guy that came up afterwards, he was a little arrogant, cocky, and
Oh,
creeped
yeah.
me. He creeped me out. If you
Oh,
could just
that's
see
that's
his-
whose phone he was using.
Yeah, if you
So
could seen his
Mr. Manuel was
facial
using-
expressions.
Mr. Manuel was using this, is alleged to have been using Mr. Goodman's phone, and Mr. Goodman was alleged to have been using Mr. Manuel's phone.
It's like, why don't they get in trouble for
They do it in jail.
that? Oh,
When we call the jail, let them know they can cut off all their privileges, they can
Yeah.
lift jail sanctions.
We've done that. Yeah.
We have to do it regularly
so
for the dedicated docket particularly.
don't let anybody have any privileges. If it ain't your lawyer, you can't talk to him.
We've cut off privileges more than one time.
Been doing it, what, about a couple times a month now?
Yeah. I think
Like
it's
every-
a,
It feels like every week.
I think it's a good move, especially for DVs and especially for having any contact with the DV victim, which can lead to new charges, you know, so
And
those are all Adam
They don't
Pfeiffer
get it.
specials and fears.
well, now I get them too, because so many of the DVs get routed to Judge Ward for consideration for
Yeah, for
the
D-
DV court.
Yep.
Well, guess what? He ain't got no.
Yeah, that's not, that's probably not gonna make it through the DV court.
So the idea was we'd like to see him in DV court, but he has to, I think I said, Judge, I think the temptation might be too strong.
You warned her. You did warn
I
her
said,
not to do that.
When they're out of custody, I feel like maybe we just don't know what happens, but also I feel like there's less of a reason to.
Yeah,
When you're in custody, I kind of
They're in
understand
love.
there's
I
like,
mean,
oh,
they're-
there's nothing else to do,
Yeah.
so I'm gonna call the person I care about. Or I purport to care about.
Yeah. Yeah.
And they were talking like they were best
Right.
friends, like.
And if she says, that
There's
if
nothing there,
she or
I'm like-
she, if the complaining victim says it's okay, then it's okay. And that's not how it works.
No. Well, and he's also got PPO cases. And it sounds like Judge Koenig is ready to just say, we're just gonna give you 93 days of the bond.
Yeah, I mean, I think that's fair, you know,
It's-
I mean, the,
You gotta follow court orders.
yeah,
It's-
I mean,
It makes me more upset when people don't follow court orders than when they don't follow the law, because the law, there's a lot of them. You aren't directly told all of them.
well, and.
But court orders,
Correct.
you're personally told one-on-one, here's what's the.
And you get a piece of paper.
Order is.
All right, Mr. Harris, how are we proceeding
Wait,
on
wait.
the,
Okay, now go.
okay, Mr. Harris, how are we proceeding on the scheduled plea for 26-00275? And then I'll let Ms. Kachukas chime in.
It is my understanding, Your Honor, that we will be proceeding with the plea.
All right, Ms. Kachukas.
Thank you, Your Honor, but I don't think I have anything else to add.
Yeah, all right. I think we set it for plea and so Mr. Harris, may I inquire of your client of their misdemeanor advice of rights?
Yes, Your Honor.
All right, so Ms. Mendenhall, you understand you have the following jury trial rights, and I'll walk you through those rights. We'll be amending count 1 to read a disorderly person. It's punishable by 90 days and or $500. There's a restitution amount of 8603. And there is an agreement between Mr. Harris and the people of no upfront jail. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney James Harris, and he would be present to cross-examine any witness or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court ordering witnesses appearing in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the disorderly person instead. Is it still your wish today to waive your jury trial rights and plead guilty to the disorderly person?
Oh, yeah.
Is that, you're gonna have to say yes or no, ma'am.
It's just like moving forward, correct?
It's moving forward and you're most likely gonna be going to probation and doing a report for probation.
Report.
That's not
recommended
like
to
having the,
probation. They're not necessarily saying you're going to be sentenced to probation, but you're going to be going downstairs to probation to do an interview with
Till-
them regarding.
Yeah, until I get to the report, I won't know what your sentence is gonna be.
oh, okay, okay, okay.
I know that if I take the plea and I follow the Killebrew agreement, there'll be no upfront jail.
Okay, okay, I understand now.
All right. Did you still want to waive your jury trial rights and plead guilty?
Yes,
Okay. And if you raise your right hand as best you can, do you solemnly swear affirm to tell the truth, the whole truth and nothing but the truth under penalty of perjury?
yes, Your Honor.
All right. I'm going to bring your attention back to,
Your Honor, before we get a little bit further, I would just like to ask that we inquire a non-traditional question of a clarification of what the possible sentences could be.
okay, the ultimate penalty for disorderly person is 90 days under $500. And then there's a Killebrew agreement between Mr. Harris and the people that you receive no upfront jail. If I was going to do something different from that agreement, you'd have the opportunity to withdraw your plea. You understand
I
that?
understand.
And just a clarification that it is still possible that Your Honor could sentence her to probation. Depending on the
Yes, yeah,
contents.
I could send you to probation. I could make it not probation. But you'd have the opportunity to withdraw your plea if I sentence you to jail. Okay,
Right, okay.
all right,
I just want to make sure that
No,
was clear due to the.
perfect.
concerns.
All right, I will be,
What they're going to be recommending. to the judge.
Do
Still-
all those right. Okay.
Still make my argument. Being sentenced to be.
All right.
all right, I'm going to bring your attention back to May 12th, 2025 at 2404 Sterling Avenue in the city of Lansing. Were you at 2404 Sterling Avenue in the city of Lansing on May 12th, 2025?
Yes, Your Honor.
And at that time, did you have the attorney to intentionally attack the property of Stephen Tamanakia?
Tamanica. Was that a question, right?
Yeah,
Yes, well, no, Your Honor, it was intention, it was more like provoked.
okay, it was provoked, but you intentionally did that
Yes.
after, and what did you do?
I took a rock and busted the smallest window in the house.
All right. And that's for the restitution of 8603. That's
Yeah,
for the
yes, ma'am.
restitution.
Yes, sir.
Anything towards the factual basis for jostling Ms. Kachukas?
Your Honor, I believe we satisfied, or did we get venue?
Yeah, we got venue, and I think that she indicated that she attacked property of another for a certain amount,
Then I
which I think would
satisfy the
satisfy.
underlying charge.
Yeah. Mr. Carries.
Yes, Your Honor, I believe that would satisfy the factual
Okay.
basis.
I find the factual basis to be knowing, voluntarily, and accurately made. And we're going to refer this to probation. That doesn't mean you're going to get probation.
I
Okay,
understand now, Your Honor.
it's just a report that'll be done for me. And then we'll see what options are available to us.
Yes, sir.
Probation could be an option. A sentencing will be an option. Restitution's an option, but I'll decide what options are available to us. And we'll set the sentencing for
August 31st.
August 31st at 1:30. All right, so we've set this for August 31st at 1:30. If you go down to probation, and they'll take a report from you, and then we'll see what options are available to us at sentencing,
So
okay?
get that done first.
Yeah, and then they'll do a report for me, and then we'll make a decision on what we're gonna do. And probation is one floor down all the way to your right.
Very familiar.
Okay,
with it.
all right.
Your Honor.
All right, anything else for the record in 26-00275, Ms. Kachukas?
No, Your Honor, thank you.
Mr. Harris.
Nothing from the defense, Your Honor.
All right, Ms. Mendenhall, we'll see you on August 31st at 1:30. You should be all set.
Yes, sir.
Thank you.
Did you want
I do
to
have the
put the
rest of
pink
the
sheet?
sheet.
Yeah.
Just have a seat. I gotta take you down there because I need to file. They'll need to file before you can do anything. For probation, they'll need your file, but.
Oh,
Court
okay.
staff.
No, it didn't.
Court file.
So just go ahead.
Here's the file.
My mom is sitting outside.
Okay. I know, but you gotta have a seat because probation won't do anything until I have the file.
I don't have like an hour.
It's not gonna take an hour.
Okay.
Yeah, a couple. All right, so we'll wait. I'll just leave these here. I have 5 left that you're gonna do a dismissal or substitution and then,
Yes, I think
Is it printing now?
2 of them are gonna be citizen orders, 3 should be.
all
Is
right,
it printing?
all right.
I don't know, I was trying to do
And
something.
then we can do that before, after the sentencing and then,
Okay.
and then we'll make sure
I need the referral.
we'll make sure
Well, I
that
needed to write it down. Hang on.
Oh,
he has
okay.
a
Trying to get that
130
print.
PSI.
I don't envy you.
Yes, and I'll be bouncing back.
All right.
James
all right,
actually
all right.
loves it.
Can we make sure that the referral sheet includes the victim statement because it is a victim crime?
Yes,
Okay.
yeah,
I know there's been some confusion and
yeah,
things
they,
going down.
they usually, I don't know what they do, you know, I don't know what they
Okay,
do.
did that?
I just had one where it wasn't checked and it was like a DB case and I was like.
It's trying,
Let's
it's doing
try.
something.
My first.
Unheard of. They ain't gonna do nothing for the file. You
Yeah, and the one difference that when I was a prosecutor, that we were never around for the
But you
sentence.
didn't-
No, they will start yelling. at
Yes.
me.
Now you guys go to the sentences.
In 50-50, they don't.
Yeah, and I know, but we never did, and it's a good idea. It's not only a good training idea for circuit court,
Okay,
but it's a
thank you.
good idea because often the prosecutor knows more about the case than anyone else.
Yeah, and if there's something that's inaccurate in the PSI. the only time it comes
Didn't
out-
print.
Yep,
You try
so
print it again, Marcy.
Okay.
Are you gonna go back?
what were you trying to print?
The notice. It's not being friendly.
I need to rank some.
Why don't we just mail it to her? Oh, here it goes.
Are you heading back? Or you gonna stay here?
Make your way here until we.
I'll just figure it out.
So nobody's handling the sentencing for for the
Yes,
public defender's
the
office.
postfer after being denied. you can-
I will
All right.
lock up the courtroom when I come back because I have to come back.
Or up the.
Yep. I can lock it.
Well, I gotta come back and get my stuff.
Oh, all right.
You want, I can give her the yellow copy.
All right, we'll see everybody after lunch.
See you after lunch,
Have a
right?
good day.
Thank you.
Are you just walking there?
No, I've got my packet.
Good.
Print 2 copies of that. I just. Yep.
is so innocent right now. It's like that. She can't put free time on me. You don't have to want me to. Honestly, that's but don't tell you that the drink so she did, she broke it, but I went to the store and I picked it. She goes, I show you the picture of she left it. No, I never done that. That's what she might be, I figured I could actually not that on that one, you fix it, but yeah, but it never, I think, they never like, it's kind of, I check it, I will take the report, I'll get, I'll find it, that way, never. Yeah. Sometimes you get, but, you don't know how, she can get the, then I
All right, and I have your Gary Apps, is that?
Yeah,
Is
good
that for
afternoon.
Pennsylvania?
Yeah, exactly.
Is that for Mr. Davis or Pennsylvania State Employees Credit Union?
For Mr. Davis, I'm subbing through a third party, so I don't know the status, but I was told to show up for a continuance request.
Right. So you're subbing for Mr.
Habibi. Yes, sir.
Okay. And Mr. Bankstein, you're here for Pennsylvania State Employees Credit Union?
That's correct, Your Honor.
All right. So I'm going to go ahead and call that case, and then I'll give the parties an opportunity to speak as part of the pretrial, and then Mr. Apps, you can explain that to Mr. Bankstein, and then if need be, I can fill out a pretrial statement. But you'll get the opportunity to meet each other, and you can explain what we're doing here today, so that we're on the record.
You have him for background.
Mr. Mr. Apps,
I
be
would
careful with your background noise.
Yeah, I'm in the hallway down at the courthouse. The people down the other end of there arguing. I'm not sure where I can go to get out of their noise.
Okay. All right.
I would just settle for your standard pretrial order, Your Honor, rather than take any more of your time.
All right. Well,
that works for me too, Your Honor.
All right. All right. So we're on the record in docket 2602051. That is Pennsylvania State Employees Credit Union versus Anthony Davis. Appearances for the record, Mr. Bankstein.
Good afternoon, Your Honor. Michael Bankstein, P69778 on behalf of Pennsylvania State Employees Credit Union.
And Mr. Apps.
Yes. Good afternoon, Your Honor. Gary Apps, P046306, subbing on behalf of Adam Habibi, on behalf of the defendant Davis.
All right. This is the time set for pretrial. I've had the opportunity to speak with both litigants, and we're just going to fill out a pretrial statement. We'll be responsible for the signing and scanning this into the court system, and then provide you a copy for each of your records. So would that suffice, Mr. Bankstein?
That works for me, Your Honor. If it's pretty standard terms, which I imagine they would be.
It really is, and anything that I need to clarify, I can do that. Mr. Apps, does that work for you?
Yeah, I see alternate standard 60, 90, 120, something like that. Whatever the court likes is
Yeah.
fine by me.
Yeah, that sounds like the typical scheduling order. I'll put it on case. So this is on case 26025051, and that is Pennsylvania State Employees Credit Union. And that's represented today by Michael Bankstein. And then we have Anthony Davis, and he's represented today by fill-in counsel, Mr. Apps.
Yes, sir.
Pretrial consent was held on this day, which is July 20th, 2026. Appearing were Michael Bankstein, and Anthony Davis, and and Gary Apps. We usually term this as a breach of contract. Mr. Bankstein, is there anything you want to add to that? I don't know anything about the case.
Not really. It's you're pretty run of the mill. I would say, personal loan and breach of contract. That's pretty consistent with what we have in the complaint, Your Honor.
All right. We kind of use that as a blanket. All right. Do you anticipate any? We'll keep the motion for summary disposition and response aside. Do you expect any more pleadings in this matter, Mr. Bankstein?
Not other than the MSD that were
All right.
not other
Mr.
than
Apps, do you expect any other pleadings in this matter?
I do not, sir. And like Michael said, the MSD is probably where it's going to end up.
All right. So I'm going to put none anticipated motions. We'll do a motion for summary disposition. And response, and that can be filed at any time. That can be filed while we're in discovery if you choose. Mr. Bankstein, do you expect any consolidation in this case?
No, there's no other transaction or occurrence. This is just this defendant, this personal loan.
I'm going to place for admissions of fact or exhibits. It's not applicable till after discovery. And we'll set discovery time at 90 days. So it'll be until October 18th, 2026 for the scheduling order for discovery. I'm going to put not applicable any expert witnesses. I think Mr. Bankstein, have all damages been pled for?
They have, Your Honor, just the $14,230.03. We don't need to amend our pleadings.
All right. I'm going to put not applicable till joinder of claims till after discovery. Mr. Bankstein, have you paid for a jury trial in this, or is this an estimated bench trial?
This is a bench trial, Your Honor. We did not request, nor do I believe defendant requested a jury trial.
And Mr. Apps, you'd verify that this is not a jury trial, or a fee has not been paid for jury trial?
Yeah, Michael knows more about this than I do, but I work for these debt settlement companies all the time, and they never request a jury trial.
I can't recall the last time even a pro se defendant has asked for a jury trial.
All right. We'll do the estimated time of trial be a half day, that's to give or take, and we'll set it after discovery. Possibility of settlement, I'm going to put negotiations are to continue. Mr. Bankstein, can you think of anything else to add to the pretrial statement?
I cannot, Your Honor.
Mr. Apps, can you think of anything to add to the pretrial statement?
Nor I, Your Honor. Thank you for your indulgence.
All right. So we'll put none at this time. I'm gonna avoid the case evaluation and mediation at this time, but I'd be open to any request for mediation or evaluation. And then Mr. Bankstein, may I sign this on your behalf?
Yes, Your Honor. And I'm in agreement that, especially when there's an attorneys on both sides, there's really no need for a mediation or anything like that.
Mr. Apps, may I sign this on your behalf?
Yes, sir. You certainly may. Certainly may, sir.
All right. I'm going to indicate that I'm going to sign this on today's date. That's July 20th, 2026. I'll sign that as sitting district court judge. So really, the only thing we did here was motion for summary disposition, and response can be filed at any time. And we've set discovery out for 90 days. Do you have any questions of me, Mr. Bankstein?
I have nothing further. I have no questions, Your Honor.
Mr. Apps, do you have any questions of me?
No, sir. Thank you again for your working with us.
Oh, all right, no worries. You should be all set. We'll provide a copy to each of the litigants, and then we'll be responsible for signing and scanning the pretrial order, okay?
Thank you.
Thank you,
Thank
Your
you,
Honor. Have a
Michael.
great day. Thank you.
All
Gary.
right, you should be all set.